You know what 3 types of questions never to ask during cross-examination? You don't? Come join me, I'll tell you what they are. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. The first type of question you never ask a witness on the stand on cross-examination is, why? You never ask an open-ended question. So, for example, doctor, can you tell us why you did that? Now, what does that do? It allows the witness to go ahead and give a long-winded explanation to the jury about why he did what he did. Now, why don't you want that? Because cross-examination, the whole purpose is to ask the witness direct leading questions that call for either a yes or no answer. I want to be able to explain to the jury what occurred by getting the witness simply to agree or disagree with certain statements that I'm making. If I now ask a witness on the stand, tell us why you did what you did, what happens? Now he has the opportunity to ramble on for a few minutes, and if I try and stop him, the defense is going to stand up and object. The judge is going to yell at me because I'm the one who asked the witness the question. And if I don't like the answer, I can't stop the witness in mid-sentence. And what will happen is that the jury will look at me like, why did you ask the question? Okay, now I look bad because I'm trying to stop the witness from answering the question. So that's one key thing you never ask during cross-examination. The second type of question you never ask is, tell us or explain to us the reasoning behind what you did. This is similar to the first one. In other words, you ask an open-ended question, but now you never want to ask the witness to explain what he or she did. Because again, it gives them the opportunity to now explain, to take over what you are trying to accomplish during cross-examination. The last thing you never want to do on cross-examination is ask a witness a question to which you do not know the answer. Why is that? Because not only will it surprise you, but it could destroy and ruin your particular case. How do we know information and testimony that a witness is going to give at the time of trial? Well, during the course of the litigation process, we have the opportunity to question different witnesses. That's known as discovery. And we have the opportunity to question them at pretrial testimony sessions, known as question and answer session, or the legal term is a deposition or an examination before trial. And that's done in an attorney's office, under oath, with a court reporter there to take down all the questions and answers. Before trial, we will know exactly what a particular witness will testify to. And that is why when you have a witness on the stand, and now you have an opportunity to get up and cross-examine and search for the truth for what that witness is talking about, you don't want to ask the witness a question to which you do not know the answer, because that answer not only could shock you, but it could destroy your case as well. So this is just a sampling of 3 things you never want to do on cross-examination here in the state of New York. So why do I tell you this? Well, I tell you this because chances are you have questions and concerns about your particular matter. And this type of video is designed to give you an insight and an understanding into how the lawsuit process works here in the state of New York. And if you have legal questions, what I encourage you to do if your matter happened here in New York is pick up the phone and call me. I answer legal questions like yours every single day. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks so much for watching.